They convicted Danny Ruiz of murder in 1994. Then in 2019, someone found the witness statement prosecutors swore didn't exist, a signed affidavit with a name, an address, and an alibi that never reached the jury. So why did the lead detective's own case file list a witness who, according to the trial transcript, was never found? Here's what the jury heard. On the night of March 3, 1994, a convenience store clerk on East Fillmore was shot twice behind the counter. Detectives said they canvassed the block for 2 weeks. No one saw anything. The only evidence tying Ruiz to the scene was a partial thumbprint on the register and a jailhouse informant who claimed Ruiz confessed. The prosecution told the jury flatly that no independent witness existed. 12 people believed that. Deliberations took under 3 hours. Ruiz got 25 to life, and the case went into a drawer marked closed. In 2019, a paralegal working an unrelated records request pulled the original 1994 detective's spiral notebook from a warehouse in Fresno County. The kind of notebook that never gets scanned, never gets indexed, just boxed and forgotten. Inside was a name, Carla Voss, an address 3 doors down from the store, and a line in the detective's own handwriting dated 4 days after the shooting. See Voss, saw male exit rear door, not suspect height, will re-interview. There was no second interview in the file. There was no Carla Voss anywhere in the trial record. She existed only in a dead man's handwriting, in a box nobody opened for 25 years. Here's the contradiction that record can't survive. At trial, Detective Holloway testified under oath that every possible witness was located and interviewed, and none could identify a second individual at the scene. That statement is the entire foundation for the prosecution's theory that Ruiz acted alone and was seen alone. But his own notebook says he found a witness, 4 days in, who described someone of a different build leaving through the back, and that he intended to go back and never did, or never disclosed it. Chain of custody, meaning the documented trail proving evidence hasn't been altered or lost, doesn't just apply to a gun or a blood sample. It applies to a name. And this name broke the chain completely. Why did this sit for 25 years? Because the notebook was never subpoenaed. Defense attorneys can only request what they know exists, and in 1994, detective field notes weren't standard discovery unless specifically asked for by name. Ruiz's public defender, carrying 11 other active cases, asked for all witness statements, a request the department satisfied with the official interview log, which listed 0. The notebook stayed in Holloway's personal files, then his retirement boxes, then a county storage unit that nearly got liquidated in a 2016 budget cut. It survived by accident. Carla Voss, if she's still alive, was never told her name was in a homicide file at all. But the notebook wasn't the strangest part. Buried 3 pages later was a second entry dated the same week. A phone number, no name attached, next to the words informant recanting, says DA pushed the statement. That's the jailhouse informant, the one whose testimony carried the case. 2 independent threads sitting 3 pages apart in the same forgotten notebook, both undermining the same conviction, and neither one made it anywhere near a courtroom. Now remember the thumbprint. The partial print on the register was the only physical evidence at trial, and analysts called it a likely match. Not a certainty, a likelihood. If Carla Voss's second man existed, that print stops being proof Ruiz pulled the trigger and becomes proof he touched a counter, maybe hours earlier, maybe as a customer. The entire case was built to make a coincidence look like a confession. If the notebook is authentic, and forensic document examiners in the 2020 post-conviction hearing say it is, then the conviction rests on a detective's sworn statement that contradicts his own private record, and an informant who says he recanted before trial even started. Who benefited from that notebook staying in a box? Holloway retired with a full pension in 1998 and died in 2011. The informant was released 8 months early. The DA who tried the case became a sitting judge in 2003. Carla Voss has never been located. Not in 1994, not in 2019, not now. No death certificate, no forwarding address, No answer at the door 3 doors down. The woman who may have seen the real killer walk out the back door is still, after 30 years, the witness nobody can find.